Good morning, everyone. A warm welcome to panel number 4, which is titled Institutional Safeguards for Democracy. We have 4 interesting speakers lined up for today, for this morning session. And I will introduce them in the order in which they will speak. Each of them will speak for about 10 minutes, after which there'll be, and after each person's intervention of 10 minutes, somebody will translate in Kannada for a few minutes. And then we'll have a panel discussion. So my own name is Rinku Lamba, and I teach political science at the National Law School in Bengaluru. So our speakers, going in the order in which they will make their comments, is first of all Dr. Aparna Chandra, who is Associate Professor of Law at the National Law School in Bangalore, where she also holds the M.K. Nambiar Memorial Chair on Constitutional Law. Aparna is a constitutional lawyer with an expertise in Indian constitutional law, among other areas. She also has published extensively, not in this area alone, but also in the domains of human rights, gender and the law, and judicial process reform. After her, we'll listen to Honorable Dr. S.Y. Qureshi, who has served as the 17th Chief Election Commissioner of India. He has written a book called, it's about the Indian election, the great Indian election, called An Undocumented Wonder. But he also has interests in old Delhi traditions and has written a book on some of those issues as well, pertaining to heritage and old Delhi. Professor Sridharan, who is joining us, will speak after Mr. Qureshi. And Professor Sridharan is a well-known political scientist who is presently serving as the Academic Director and Chief Executive of the University of Pennsylvania's Institution for the Advanced Study of India in New Delhi. His research publications have been in the areas of election studies, party systems, and coalition politics, as well as the political economy of development. After him will be Professor Arun Thiruvengadam, who is Professor of Law at the National Law School in Bangalore. He also holds the V.R. Krishna Iyer Chair on Public Law and Policy Choice at the NLS. He has published widely in the fields of constitutionalism, but also law and development, as well as law and politics in South Asia. So I hand it over now to Dr. Aparna Chandra, who will speak for about 10 minutes. I will keep time and figure a way of showing you when there's 2 minutes left.
Thank you. And I'm going to jump right in. Since this session is titled Institution Safeguarding Democracy, let me just start by looking at the overview of the institutional structure within our Constitution. So in the constitutional tradition of which India is part, the way democracy is protected by institutions is by dividing state power into various institutions so that no one institution, and by implication the persons controlling that institution, no one institution becomes all-powerful, and each institution has limited powers, and the idea is that each institution serves as a check and balance with respect to the powers of other institutions. So there's a vertical division of power, which is the federal division, and I know there have been conversations about that in the previous sessions, and there's a horizontal division of power, which is a separation of powers traditionally thought to be a separation between 3 branches of the state, which is the legislature, the executive, and the judiciary. Today, I will be focusing on the judiciary, but before I do so, I want to make 2 preliminary remarks. One is on the importance of what we today know as the 4th branch institutions. So that traditional model of separation of powers between 3 branches of the state, the legislature, executive, and the judiciary, is today being rethought to think of other institutions that also play a very crucial role in limiting, controlling, and checking state power, and to think of them as being an additional, a separate branch of the state which requires the same kind of protections and the same kind of institutions, the same kind of safeguards, and the same kind of powers that the traditional 3 branches have. These are called variously 4th branch institutions, guarantor institutions, integrity branches, and the election commission, on which we'll hear a bit more, is typically thought of as being one such institution, the CAG, the auditors as other institutions. So for example, the South African Constitution calls such institutions state institutions supporting constitutional democracy. And that of course reminds us of the topic today. So, so therefore, just to think that, just to think of other kinds of institutions that are very important in protecting democracy, and how we should therefore conceive of these institutions, particularly their internal structure, their working, their independence, so on and so forth. I know some of my colleagues will be talking a bit more about fourth branch institutions, so I won't go into them too much, except to say that the independence of these institutions has been called into question in recent times, and we've seen a range of judgments coming from courts, but also more public conversation around the structure of these institutions, and we need to perhaps have that mental shift of thinking of these institutions as being, say, on par with the judiciary when we talk about its structure, its working, its importance, and therefore its independence. Okay, with that, I want to move to focusing on the judiciary, and my preliminary point here is that I don't want to overstate the importance of the judiciary in protecting democracy. It's obviously a very important document, but it's obviously a very important institution, but at best it can play only a supporting role. And sometimes when we talk about the judiciary, particularly within law schools, but also sometimes in the broader political sphere, it's as if the judiciary is the best guarantor or the savior of democracy, and that may be overstating the case for the judiciary. Having said that, the judiciary is of course very important in terms of protecting democracy, and it's one institution where we've had robust discussions on institutional design which would best serve this function of protecting the constitution, and especially we've had a lot of conversations around judicial independence. But when we talk about the judiciary, we talk about it typically in two ways. One is we look at the outcomes from the judiciary in specific cases, and we see whether that's, whether we agree with that outcome or we don't agree with that outcome. And the second is when we are talking about the structure of the judiciary and threats to its independence, we think of external threats. We think of threats from the executive, for example, but we've not had at least very detailed conversations within our public discourse, within our legal discourse, our institutional discourse, of the internal workings of the judiciary, which may enhance or limit its ability to perform its role in safeguarding democracy. So that's what I'm going to be talking about. So my main point, is it? Okay. My main point, therefore, is that we need to focus on the internal structures and processes of the judiciary if we want to support its ability and if we want to shore up its ability to perform its role. What do I mean by this? Let me make two points, focusing on the Supreme Court, again recognizing that the Supreme Court is just one amongst an entire architecture of the Indian judiciary, but it has a very important role, and so therefore I'm focusing on the Supreme Court to substantiate the point that we need to focus on the internal structures of the Indian judicial system. So the Indian Supreme Court is tasked with protecting constitutional governance in multiple ways, but to give two examples, one is the enforcement of fundamental rights, where one can directly approach the Supreme Court for enforcement of these rights. Second is federalism, to decide federal disputes. This is just to name a couple, but of course the Supreme Court has a very important role to play in ensuring that the governance of the country is carried out in accordance with the Constitution. This is perhaps its most important function. But it also has an appellate function. It serves as the final court of appeals in all civil and criminal matters. And when the Constitution was being debated and drafted, the understanding was that most civil and criminal cases would end at the high courts, except when the high courts themselves thought that and certified that the case was so important, raised some very important issues, and the Supreme Court should get involved. The Supreme Court could also exceptionally, in very extraordinary situations as a residual matter, take up cases from any court or any tribunal in the country, take up cases on appeal, if it thought that it raised some very, very important question. But this was seen as a very extraordinary residual power. And this is called the special leave to appeal, and the petition that is filed is called the special leave petition, or the SLP. Now, like I said, this was seen as an extraordinary power. The primary function of the courts was to protect, of the Supreme Court, was to protect constitutional governance, and it had an appellate power that was there, but to be exercised only when very important questions had to be decided. Today, however, and this is something that's happened over time, but today, however, the functioning of the court has completely flipped around. So today, over 90% of the court's docket, it is made up of routine appeals, and most of them exercising that extraordinary residual SLP power. Constitutional matters make up less than 8% of the court's docket, and public interest litigation, which we see, is a very highly visible part of the court's docket, is less than 1% of the court's docket. Today, the court is bogged down by routine civil and criminal matters. And why is this of concern? This is of concern because the court does not have the time to hear important constitutional matters, at least in a timely way, or at the very least, it can say that it does not have the time to hear important constitutional matters, which drag on very often, and when they drag on, they can become fait accompli. And of course, the electoral bonds case, which perhaps we'll discuss a little bit more on this panel, is an example of a case that was filed in 2017, gets to be decided in 2023, with having had one general election and countless state elections in between, when the electoral bond scheme, which was ultimately found to be completely unconstitutional, was in play. So just to say that, therefore, and constitutional matters, therefore, are the most delayed part of the court's docket. On average, the most important constitutional matters, which are to be decided by benches of 5 judges or more, called constitution benches, are on average take about 8 years, which is more than any other type of case in the Supreme Court. So preserving the constitutional function of the court is a distinct function, is of crucial importance, either by having permanent constitution benches or by even having a separate constitutional division. And that's an idea that's been floated around since at least the 1980s, but that's not something that the court has really worked on. So that's one sort of insight into the working of the court and just internal organization of the court that may end up impacting the ability of the court to safeguard democracy. The second, again, as a let me just check on time, just to flag something about the structure of the court which may impede its ability to safeguard democracy, is the office of the Chief Justice of India. Now, the Chief Justice of India heads the Supreme Court and the judicial institution. It's an administrative post, which administrative power for efficient working of the court. Over time, however, this post has accrued a vast range of powers that is now impacting the working of the Supreme Court on the judicial side. And again, to take one example, and there are actually many more, but to take one example, the Chief Justice of India is the master of the Supreme Court's roster. That essentially means that they get to decide which judges hear what matters and when. So the priorities of the court and which judge gets to sit and hear which matter is something that the Chief Justice of India decides. And data shows that Chief Justices, and this is not signaling out one Chief Justice, this has been a pattern since the very beginning of the court. Chief Justices have used this power to influence outcomes on the judicial side. And of course, the clearest example, so to speak, from the horse's mouth is the judges' press conference that happened in 2018, if I'm not mistaken, 2017 or 2018, where the 4 senior-most judges of the Supreme Court after the Chief Justice alleged that the then Chief Justice was assigning cases to specific benches in order to influence outcomes. And of course, the allegation was that democracy was in danger because of this practice. But I've done a study on this, and statistics show that the Chief Justices use this power with an eye to outcome. So one, they over-assign themselves to benches as compared to any other judge, but also these benches that they construct invariably side with them in terms of the decisions that the court reaches. So the Chief Justice of India is rarely in a minority in in any of the decisions of constitution benches that the Chief Justice is a part of. So the Chief Justice, from 1950 onwards till date, there have been about 2,000 odd constitution bench decisions. The most important, yeah.
So another 1 minute.
1 minute. I'm just wrapping up. This is the last point. Chief Justices have been part of there have been over 2,000 constitution benches, which is benches of over 5 judges or more, deciding the most important cases. And out of these, Chief Justices of India have been in a minority only 13 times. And this is significantly by degrees different from any other judge who's been part of the constitution bench, because no other judge can have has this power to carry the majority with them almost always. And that again is an indicator that Chief Justices are constructing constitution benches with an eye to outcome, picking and choosing which judges will sit on which bench. There are no standard guidelines. The Supreme Court has repeatedly refused to put in place either an institutional structure or guidelines in order to ensure that the assignment of cases in these matters is not at the sole unaccountable discretion of the Chief Justice. The court has refused to do that, and this is a huge concern because the most important cases before the Supreme Court today are being decided on the basis of the Chief Justice deciding which judges will be on that bench. So rethinking the internal institutional structures of the court and more broadly of the judiciary is crucial for protecting its ability to protect democracy. Again, I don't want to overstate the importance of the judiciary. Institutions can do only so much, but to the extent that institutions such as the judiciary are important and they provide important safeguards and guardrails, it's crucial to think of the nuts and bolts of these institutions from the inside and not just the outcomes in the specific decisions that they give. So let me stop here, and I'm happy to take questions at the end.
Thank you. So we'll wait for the translation to happen.
Good morning, everyone. I am Vinay GP, lecturer and researcher in Department of Journalism and Mass Communication, Kuvempu University, and I am here to translate the Madam Dr. Aparna Chandra Madam in Kannada language. I am providing it in 2-3 points. ಪ್ರಜಾಪ್ರಭುತ್ವಕ್ಕೆ ಸಾಂಸ್ಥಿಕ ಸುರಕ್ಷತಾ ಆಯಾಮಗಳು ಅನ್ನೋ ವಿಷಯದ ಮೇಲೆ ಮೇಡಮ್ ಅವರು ತುಂಬ ವಿಸ್ತೃತವಾಗಿ ಮಾತನಾಡಿದ್ದಾರೆ. ಸಾಂಪ್ರದಾಯ ಅವರು 2 ವಿಷಯಗಳ ಬಗ್ಗೆ ಗಮನ ಸೆಳೆಯೋದ್ರ ಮೂಲಕ ಈ ಒಂದು ವಿಷಯವನ್ನು ಅವರು ಮಂಡನೆ ಮಾಡಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಮೊದಲನೇದು ಸಾಂಪ್ರದಾಯಿಕವಾಗಿ ನ್ಯಾಯಾಂಗದಲ್ಲಿ ಅಧಿಕಾರ ಹಂಚಿಕೆ ಯಾವ ರೀತಿ ಆಗಿದೆ ಅನ್ನೋದು ಒಂದು. ಮತ್ತೊಂದು ನ್ಯಾಯಾಂಗದ ವ್ಯವಸ್ಥೆಯಲ್ಲಿರುವಂಥ ರಚನೆ ಏನು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಮೇಡಮ್ ಮಾತನಾಡಿದ್ದಾರೆ. ಮೊದಲನೇದಾಗಿ ನ್ಯಾಯಾಂಗದಿಂದ ಬರ್ತಿರುವಂತಹ ತೀರ್ಪುಗಳ ಬಗ್ಗೆ ಮಾತನಾಡ್ತಾ ಇದ್ದಾರೆ. ಅದರಲ್ಲಿ ನಡೀತಿರೋಂಥ ವಿಚಾರಣೆಗಳು, ಕೇಸ್ಗಳ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದಾರೆ. ಸೊ ಅದರಲ್ಲಿ ದೇಶದ ಭವಿಷ್ಯವನ್ನು ನಿರ್ಧರಿಸುವಂತಹ ಒಂದು ಕೇಸ್ಗಳ ವಿಚಾರಣೆ ಎಷ್ಟು ನಡೀತಾ ಇದೆ ಅಂತ ನೋಡಿದ್ರೆ ಅವುಗಳ ಸಂಖ್ಯೆ ಬಹಳ ಕಡಿಮೆ ಇದೆ. ಅವು ಪ್ರತಿದಿನ ತಮ್ಮ ರುಟೀನ್ ವಿಚಾರಣೆಗಳಂದ್ರೆ ಸಾಮಾನ್ಯವಾಗಿ ನಡೀತಿರುವಂತಹ ಕೇಸ್ಗಳು ದಾಖಲಾಗಿರುವಂಥವುಗಳನ್ನೇ ವಿಚಾರಣೆಗೆ ಒಳಪಡಿಸಲಾಗ್ತಾ ಇದೆ. ಮತ್ತು PIL ಪಬ್ಲಿಕ್ ಇಂಟ್ರೆಸ್ಟ್ ಲಿಟಿಗೇಷನ್ ಇವುಗಳ ವಿಚಾರಣೆ ಪ್ರಮಾಣ 1% ಕಡಿಮೆ ಇದೆ ಅನ್ನುವಂಥದ್ದನ್ನು ಅವರು ಇಲ್ಲಿ ನಮಗೆ ತಿಳಿಸ್ಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಸೊ ಇದ್ರ ಮೂಲಕ ಕೇಸ್ಗಳ ವಿಚಾರಣೆಯಲ್ಲಿ ತುಂಬ ಅವಶ್ಯಕತೆ ಇರೋದು ಏನಿದೆ ಅವುಗಳು ಆಗ್ತಾ ಇಲ್ಲ. ಸೊ ಅದ್ರ ಮೂಲಕ ಇಲ್ಲಿ ಪ್ರಜಾಪ್ರಭುತ್ವವನ್ನು ಉಳಿಸ್ಲಿಕ್ಕಿರುವಂಥ ಒಂದು ಅವಕಾಶ ಕಡೆಗಣನೆ ಆಗ್ತಾ ಇದೆ ಅನ್ನುವಂಥದ್ದು ನಮಗೆ ತಿಳಿಸಿದ್ದಾರೆ. ಇನ್ನೊಂದು ಆಂತರಿಕವಾಗಿ ಸಾಂಸ್ಥಿಕವಾಗಿರುವಂಥ ರಚನೆ, ಇಂಟರ್ನಲ್ ಸ್ಟ್ರಕ್ಚರ್ ಬಗ್ಗೆ. ಸೊ ಅದರಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಗಮನ ಸೆಳೀತಾ ಇರುವಂಥದ್ದು ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗಿರುವಂತಹ ಅಧಿಕಾರ ಮತ್ತು ಅವರ ಕೆಲಸದ ನಿರ್ವಹಣೆ ಮತ್ತು ಅದ್ರ ಬಗ್ಗೆ ಆಗ್ತಿರುವಂತಹ ಚರ್ಚೆಗಳ ಬಗ್ಗೆ ಗಮನ ಸೆಳೆದಿದ್ದಾರೆ. ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗೆ ಯಾರು ಯಾವ ಕೇಸನ್ನು ತೆಗೆದುಕೊಳ್ಬೇಕು, ವಿಚಾರಣೆ ನಡೆಸಬೇಕು ಅನ್ನುವಂಥ ಒಂದು ನಿಗದಿಗೊಳಿಸುವಂಥ ಕೇಸ್ಗಳನ್ನು ನಿಗದಿಗೊಳಿಸುವಂಥ ಅಧಿಕಾರ ಇದ್ರೂ ಕೂಡ ಅದು ಸ್ಪಷ್ಟವಾಗಿ ದಾಖಲಾಗಿಲ್ಲ. ಅದ್ರ ಮೂಲಕವಾಗಿ ಮುಖ್ಯವಾಗಿರುವಂತಹ ಒಂದು ಕೇಸ್ಗಳಿರ್ಬೋದು, ವಿಚಾರಣೆ ನಡೆಸುವಂಥದ್ದು ಇರ್ಬೋದು, ಅವುಗಳು ಒತ್ತಡದ ಮೂಲಕ ಅಥವಾ ಬೇರೆ ರೀತಿಯ ಪ್ರಭಾವಗಳ ಮೂಲಕ ಬೇರೆ ಕಡೆ ಹೋಗ್ತಾ ಇದೆ. ಸೊ ಅದ್ರ ಮೂಲಕ ನಮಗೆ ಉತ್ತಮವಾದಂತಹ ನ್ಯಾಯದಾನ ಆಗ್ತಾ ಇಲ್ಲ. ಅಲ್ಲಿಯೂ ಕೂಡ ಒಂದಷ್ಟು ಮಟ್ಟಿಗಿನ ಪ್ರಭಾವಗಳಿದೆ. ಅದಕ್ಕಾಗಿ ಆ ಒಂದು ಇದಕ್ಕೆ ಪರಿಹಾರವಾಗಿ ಏನು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಅಂದರೆ, ಸೊ ಸಾಂಸ್ಥಿಕ ರಚನೆ ಇಲ್ಲಿರುವಂತಹ ಸ್ವಾತಂತ್ರ್ಯ ಬದಲಾವಣೆ ಆಗಬೇಕು, ಅಂದರೆ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ಉಳಿಸ್ಬೇಕು, ಆಂತರಿಕ ಸ್ವಾತಂತ್ರ್ಯ ಉಳಿಸ್ಬೇಕು. ಅದಕ್ಕೋಸ್ಕರ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗಿರುವಂಥ ಅಧಿಕಾರವನ್ನು ಸ್ಪಷ್ಟವಾಗಿ ನಮೂದಿಸಬೇಕು. ಸೊ 1950ರಿಂದ ಈ ಕಡೆಗೆ ಅದು ಕಡಿಮೆ ಆಗ್ತಾ ಬಂದಿದೆ ಅನ್ನೋದನ್ನ ಹೇಳುವಂತಹ ಪ್ರಯತ್ನವನ್ನು ಮಾಡಿದ್ದಾರೆ. ಸೊ ಪ್ರಜಾಪ್ರಭುತ್ವದ ಉಳಿವಿಗೆ ಈ ಎರಡು ಅಂಶಗಳು ಬಹಳ ಮುಖ್ಯ ಆಗುತ್ತೆ. ಒಂದು ಮುಖ್ಯ ಆಂತರಿಕವಾಗಿರುವಂತಹ ಪ್ರಜಾಪ್ರಭುತ್ವ ನ್ಯಾಯಾಂಗ ವ್ಯವಸ್ಥೆಯಲ್ಲಿ, ಅದರಲ್ಲಿ ಬಹಳ ಮುಖ್ಯವಾಗಿ ಮುಖ್ಯ ನ್ಯಾಯಮೂರ್ತಿಗಳಿಗಿರುವಂತಹ ಅಧಿಕಾರಗಳು ಮತ್ತು ಯಾವ ರೀತಿಯ ತೀರ್ಪುಗಳನ್ನು, ವಿಚಾರಣೆಗಳನ್ನು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಕೈಗೊಳ್ತಾ ಇದೆ ಅನ್ನುವಂಥದ್ದು. ಸೊ ಇದರ ಮೂಲಕ ನಾವು ಸಾಂಸ್ಥಿಕ ರಚನೆ ನ್ಯಾಯಾಂಗದ ವಿಷಯದಲ್ಲಿ ಮಂಡಿಸ್ಬೋದು, ಉಳಿಸ್ಬೋದು ಅನ್ನೋಂಥದ್ದನ್ನ ಮೇಡಮ್ ಹೇಳಲಿಕ್ಕೆ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಧನ್ಯವಾದಗಳು.
Thank you. Dr. Qureshi, we request you for your comments. So I will intervene when that moving clock there is near 60. Not 60. 62. Yes, from 71 to 62. I won't intervene.
I don't know what it means.
It's going backwards.
Okay.
We started at
I have
90.
71 minutes.
No, we have 71, but you
Okay.
have 10 right
Can
now.
you hear me as clearly as from that microphone? Good, thank you, because I cannot stand. I have a problem with the knee. Thank you very much. My colleague Professor made a very good beginning. I would focus only on the Election Commission. I would feel that the biggest salute goes to the founding fathers of the Constitution for laying the structure of the governance that we are going to follow. And Election Commission was given so much of importance by them that Election Commission was founded, was born a day before India was born as a republic. Election Commission was already founded on 25th of January 1950. And the 6 articles which created the Election Commission were promulgated 2 months before the Constitution on 26th of November 1949. Another interesting thing is the framers of the Constitution wanted it to be so independent, so fair, and that, you know, they departed from the principle of federalism and separation of powers between state and the center, that there was a debate whether Vidhan Sabha election should be conducted by the state election commissions. And the decision was taken that if you leave it to the states, there will never be a free and fair electoral roll. The tendency will be Bengal for Bengalis, Tamil for Tamil Nadu, Kannadigas for the Kannada. There will be no India. So they said, no, it has to be a federal commission which will do those elections and which will be in charge of the electoral roll. So far-sighted, and we see it happening. The tendency in some parts of the country to keep the others out is happening. Now, free and fair election has been declared as the basic structure of the Constitution, repeatedly. And that has to be guarded by other institutions like the Parliament, by the judiciary. In fact, there was a debate whether the election should be a fundamental right. There was a lot of debate on that. But they, after some discussion, they decided that it will suffice if it is considered as a matter of fundamental importance. They did not make it a fundamental right, but in any case, free and fair elections are the basic structure of the Constitution, which cannot be tinkered with. Now, Dr. Ambedkar observed, in the interest of the purity and freedom of elections to the legislative bodies, it was of utmost importance that they should be freed from any kind of interference from the executive of the day. Very, very important and very valid, in fact more valid today than it ever was. And in fact the recent judgment of the Supreme Court was all about that. We have been demanding that instead of government of the day appointing us directly, let there be a collegium, because we are familiar with collegium. We have a collegium for so many other institutions. I was also a beneficiary of the old system, unilateral appointment by the government, but I always protested. Even sitting on that chair, you know, it is very easy for people to say, you know, these guys, when they're on the chair, they say something else. After retirement, they become wise. No, as CEC, I was interviewed by Karan Thapar, and he asked me this question. I said I would have been happier, I would have felt stronger if leader of opposition had also signed my appointment letter. And since, as you know, he is a guy who repeats and wants full clarity, he said, do you mean if Sushma Swaraj had also signed your appointment, you would have been happier? I said, definitely, because perception is important. Because if leader of opposition has also accepted you, no political party will ever then question you, because that means you're acceptable across the board, and neutrality of the Election Commission is totally non-negotiable. Now, there is a very interesting quote from Dr. Ambedkar again. There is no provision in the Constitution to prevent the appointment of either a fool or a knave or a person who is likely to be under the thumb of the executive. That's true. Now, latest Supreme Court judgment had said that for 70 years we did not make a law how Election Commission should be appointed. Of course, it is fortunate that we were always Government of India secretary level officers, and all of us delivered. Although we were appointee of the government of the day, but none of us can be faulted. You would know that we only brought glory to the country and electoral system, and we are recognized worldwide as such. At the same time, hope can never be a strategy. To hope that it will happen in the future also, we cannot bank on that. We have to have institutional check. So therefore, now judiciary support has made Election Commission very strong, but their track record is also mixed. Earlier years, definitely they were guardian angels of democracy, and one of the most important things they did was in 2003 on PUCL and ADR PIL. They said under a right to information, we should know who our candidates are, what kind of criminal cases they have, what kind of finances they have, we should know. And in 2003, Supreme Court said, yes, that's important, that's a part of a fundamental right of the voter, of the citizen to know. And it was made compulsory that every candidate will file 2 affidavits, one about the criminal antecedent, the other about the financial antecedent. And on which basis, which has been a subject of debate, on which basis we have been choosing our candidate. Another support which we got from Supreme Court was the Model Code of Conduct, which is not a law, which is the voluntary code of conduct developed by political parties with in consultation with the Election Commission. But Supreme Court puts this stamp, yes, it's a great idea, it should be implemented from the day the elections are announced. So now, important thing is that despite all this, we have criminalization of politics is one continuing problem. In our parliament today, 43% of our MPs have criminal cases pending against them. And it is not my allegation. This is given by themselves in their affidavit, sworn affidavit that I have these criminal cases against me. Many of them multiple cases. Many of them heinous offenses like rape, dacoity, murder, kidnapping. Now, Election Commission has been demanding that these guys should be debarred from contesting election. But we are told by everyone, knowledgeable person, lawyer, judiciary, that the law of the land is presumption of innocence. Till convicted, you are innocent. You have not been proven guilty. But I have a counter question, which I pose to my colleagues on both sides, on both extremes here. Now, I have a counter question. I understand that the law of the land is about presumption of innocence. But in Indian jails today, there are 4 lakh prisoners, of which 2,70,000 are under trial. That means not yet convicted. That means innocent. Yet, you have taken away 4 of their fundamental rights, mind you, right to liberty, right, freedom of movement, freedom of occupation, right to dignity. You can take away 4 fundamental rights within the ambit of the same law which you quote to me. Now, right to contest is not even a fundamental right. It's a statutory right which could be suspended. Now, the Law Commission had said that it should be suspended. There was Justice Kuldeep Singh committee which said this should be suspended. But it went up to Supreme Court. Supreme Court said, great concern, but we cannot stop it. Every candidate and every party will advertise for public knowledge that I am a criminal, I have so many cases while voting for me, please think. Now, that is not good enough. They should first answer my question, which I raised before giving this judgment. How can we take away fundamental, either release all those under trial because they are innocent? So therefore, we have not dealt with these issues with the kind of sensitivity that is required. And second issue is the state funding of elections. Supreme Court has come out with a good judgment, 3 good judgments in the last 10 days, which is very good because our faith was wavering. For the last 5, ever since the electoral bond case went to the Supreme Court, 5 Chief Justices have come and gone. And it was not urgent enough for them. Now, they are also accountable. They hold everybody accountable. We have to hold them accountable. What were they doing for 7 years? If this is not an issue of national importance, what is? And anyway, in these 7 years, lot of money has changed hands. And now the question is, these, people are asking questions, these people will go back to the court and say, look, we donated because we were promised secrecy. You have taken away that secrecy with retrospective effect. What will happen? Now, all those donors who gave crores, they have a very big law department. Their law department should have known the cases before the Supreme Court, and it could go any which way. Therefore, to this plea that, we did not know, we were innocent. Now, but it's still that issue is going to haunt all of us. You will see it in the media in the near future. I'll end on one lasting solution. Now, so electoral bonds have been declared unconstitutional, no doubt. What next? Status quo ante is not the answer. Because before 2017, all donations, 70% were cash donations and we did not know the source. So that is not acceptable, and at that time we were all howling, crying. We wanted a solution, and my suggestion which I have made, and I am now repeating and I'll write and talk about it more, let us set up a national election fund where everybody will contribute without any fear. The reason given for electoral bond was that the donor is scared. Now, donating to national election fund, nobody will be scared. And from that fund, allot the money to political parties based on their electoral performance. For instance, 100 rupees per vote. Now, one figure in the country which cannot be fudged is the number of votes that you got. If you got 200 votes, you got 200 votes, multiply by 100. So that is the solution. Nobody, I've been talking about for 10 years, nobody has talked about it, nobody discussed it. Now I hope this is an opportunity that this will be taken forward. Thank you very much.
Thank you.
ಹಲೋ, ಡಾಕ್ಟರ್ ವೈ.ಎಸ್. ಕುರೇಶಿ ಸರ್ ಅವರು ಚುನಾವಣಾ ವ್ಯವಸ್ಥೆ ಮತ್ತು ಚುನಾವಣಾ ಆಯೋಗದ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದಾರೆ. ಭಾರತಕ್ಕೆ ಸ್ವಾತಂತ್ರ್ಯ ಬರುವ ಮೊದಲೇ ಒಂದು ಈ ಚುನಾವಣಾ ಆಯೋಗ ಅನ್ನೋ ಒಂದು ಕಾನ್ಸೆಪ್ಟ್ ಇತ್ತು ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಅವ್ರು ಗಮನ ಸೆಳೆದಿದ್ದಾರೆ. ಮೊದಲನೇದಾಗಿ ಒಕ್ಕೂಟ ಮಾದರಿಯಲ್ಲಿ ಚುನಾವಣಾ ಆಯೋಗ ಬೇಕು. ಪ್ರತಿ ರಾಜ್ಯಗಳಿಗೆ ಚುನಾವಣೆ ನಿಗದಿ ಆಗೋದಕ್ಕೂ ಮೊದಲು ಮತ್ತು ಅದನ್ನು ಜಾರಿಗೊಳಿಸುವ ಮೊದಲು, ಅದನ್ನು ಘೋಷಿಸುವ ಮೊದಲು ಸಾಕಷ್ಟು ಬೇರೆ ಬೇರೆ ರೀತಿಯಾದಂಥ ರಾಜಕೀಯ ಒತ್ತಡಗಳು ಕೂಡ ಅದ್ರ ಮೇಲೆ ಬರ್ತಾ ಇದೆ. ಅದು ಹೆಚ್ಚಿನ ಮಟ್ಟದಲ್ಲಿ ಕೇಂದ್ರೀಕೃತ ವ್ಯವಸ್ಥೆಯಾಗಿ ಹೆಚ್ಚು ಕಾಣ್ತಾ ಇದೆ, ಒಕ್ಕೂಟ ಮಾದರಿಯ ವ್ಯವಸ್ಥೆಯಾಗಿ ಅದು ಕಾಣ್ತಾ ಇಲ್ಲ, ಫೆಡರಲ್ ಸಿಸ್ಟಮ್ ಆಗಿ ಅದು ಕಾಣ್ತಾ ಇಲ್ಲ ಅನ್ನುವಂಥದ್ದನ್ನ ಹೇಳಿದ್ದಾರೆ. ಮತ್ತೆ ಚುನಾವಣೆಯನ್ನು ಒಂದು ಮೂಲಭೂತ ಹಕ್ಕಾಗಿ ನಾವು ನೋಡಬೇಕು ಅನ್ನೋ ಚರ್ಚೆ ನಡೀತಾ ಇದೆ. ಅದ್ರ ಬಗ್ಗೆ ಎಷ್ಟು ನಾವು ಮುಂದುವರ್ಸ್ಕೊಂಡು ಹೋಗಿದ್ದೀವಿ, ಅದನ್ನು ಜಾರಿಗೆ ತರ್ತಾ ಇದ್ದೀವಿ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಗಮನ ಸೆಳೆದಿದ್ದಾರೆ. ಚುನಾವಣಾ ಆಯೋಗದ ಮುಖ್ಯಸ್ಥರ ನೇಮಕದಲ್ಲಿ ವಿರೋಧ ಪಕ್ಷಗಳ ನಾಯಕರು ಮತ್ತು ಸದಸ್ಯರುಗಳ ಅಭಿಪ್ರಾಯ ಬಹಳ ಮುಖ್ಯವಾಗ್ತದೆ. ಇಲ್ಲದೆ ಹೋದರೆ ಕೇವಲ ಕಾರ್ಯಾಂಗದ ಅಂದರೆ ಆಫೀಸರ್ಸ್ ಅಥವಾ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಷನ್ ಏನಿದೆ ಅವರಿಗೆ ಹೆಚ್ಚು ಸೂಕ್ತವಾಗಿ ಅನಿಸುವಂತಹ ಮತ್ತು ಅವರ ಮಾತುಗಳನ್ನು ಕೇಳುವಂತಹ, ಅವರ ಫೇವರ್ ಆಗಿರುವಂಥ ಪರವಾಗಿರುವಂಥವರ ನೇಮಕ ಆಗುವಂತಹ ಸಾಧ್ಯತೆ ಹೆಚ್ಚಾಗಿರ್ತದೆ. ಹಾಗಾಗಿ ವಿರೋಧ ಪಕ್ಷಗಳ ಸಹಭಾಗಿತ್ವ ಹೆಚ್ಚು ಮುಖ್ಯ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಮತ್ತೊಂದು ಮುಖ್ಯವಾಗಿ ಗಮನ ಸೆಳೀತಾ ಇರುವಂಥದ್ದು ಚುನಾವಣಾ ಪ್ರಜಾಪ್ರತಿನಿಧಿಗಳ ಅಪರಾಧೀಕರಣ ಹಿನ್ನೆಲೆಯ ಬಗ್ಗೆ. ಅದರಲ್ಲಿ ಕ್ರಿಮಿನಲ್ ಹಿನ್ನೆಲೆಯನ್ನು ಹೊಂದಿರುವಂತಹ 43%ಕ್ಕೂ ಹೆಚ್ಚು ಪ್ರಜಾಪ್ರತಿನಿಧಿಗಳು ಆಯ್ಕೆಯಾಗ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಇದು ನಮ್ಮ ಇಡೀ ಸಂಸದೀಯ ವ್ಯವಸ್ಥೆಯನ್ನ ಅಪರಾಧೀಕರಣಕ್ಕೆ ಒಳಗಾಗಿಸಿರುವಂತೆ ಆಗಿದೆ. ಸೊ ಅದು ಅವರೇ ತಮ್ಮ ಚುನಾವಣೆಯ ಸಂದರ್ಭದಲ್ಲಿ ಸಲ್ಲಿಸ್ತಿರುವಂಥ ಅಫಿಡವಿಟ್ನಲ್ಲಿ ಸಲ್ಲಿಸಿರೋದು ಅನ್ನೋದು ಕೂಡ ತುಂಬ ಗಮನ ಸೆಳೀತಾ ಇದ್ದಾರೆ. ಇವರಿಗೆ ಸಂಪೂರ್ಣವಾಗಿ ಚುನಾವಣೆಯಲ್ಲಿ ನಿಲ್ಲುವ ಅವಕಾಶ ಇದೆ. ಗೆದ್ದು ಸಂಸತ್ತಿನಲ್ಲಿ ಬಂದು ವಿಧಾನಸಭೆಗಳಲ್ಲಿ ಬಂದು ಶಾಸನಗಳನ್ನು ರೂಪಿಸುವ ಅವಕಾಶ ಇದೆ. ಆದರೆ ಇನ್ನೊಂದು ಕಡೆ ಭಾರತದ ಜೈಲುಗಳಲ್ಲಿ ಭಾರತ ಜೈಲುಗಳಲ್ಲಿ ಒಟ್ಟು 4 ಲಕ್ಷ ಕೈದಿಗಳಿದ್ದಾರೆ. ಅದರಲ್ಲಿ 2.83 ಲಕ್ಷ ಕೈದಿಗಳು ವಿಚಾರಣೆ ಹಂತದಲ್ಲಿದ್ದಾರೆ. ಅವರ ಯಾವ ಅಪರಾಧಗಳು ಅಥವಾ ಆರೋಪಗಳು ಕೂಡ ಸಾಬೀತಾಗಿಲ್ಲ. ಸೊ ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ನೋಡಿದ್ರೆ ಒಂದು ವರ್ಗಕ್ಕೆ ಪ್ರಜಾಪ್ರತಿನಿಧಿಗಳಾಗಿ ಮೆರೆಯುವ ಅವಕಾಶ ಇದೆ. ಆದರೆ ಇನ್ನೊಂದು ಕಡೆ ಎಷ್ಟೋ 2 ಲಕ್ಷಕ್ಕಿಂತ ಹೆಚ್ಚು ಜನರ ಮೂಲಭೂತ ಹಕ್ಕುಗಳನ್ನ, ಬದುಕುವ ಹಕ್ಕುಗಳನ್ನ, ಘನತೆಯ ಹಕ್ಕುಗಳನ್ನ ಕಿತ್ಕೊಳ್ಳಲಾಗಿದೆ. ಅವ್ರ ಕಡೆಗೆ ಸಾಕಷ್ಟು ಅಸಂವೇದನಾಶೀಲವಾಗಿ ನಾವು ವರ್ತಿಸ್ತಾ ಇದ್ದೀವಿ. ಸಂವೇದನೆಯನ್ನು ಅವ್ರ ಕಡೆಗೆ ನಾವು ಕಳ್ಕೊಂಡಿದ್ದೀವಿ ಅನ್ನೋದ್ರನ್ನ ಅವ್ರ ಕಡೆಗೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಜೊತೆಗೆ ಮತ್ತೊಂದು ಮುಖ್ಯವಾದಂತಹ ಅಂಶ ಚುನಾವಣಾ ಅನುದಾನ ಮತ್ತು ಚುನಾವಣೆಗೆ ಬಳಸ್ತಾ ಇರುವಂತಹ ಹಣದ ಮೂಲಗಳ ಬಗ್ಗೆ. ಇತ್ತೀಚೆಗೆ ಕಳೆದ 1-2 ವಾರಗಳಲ್ಲಿ 3 ಉತ್ತಮವಾದಂತಹ ತೀರ್ಪುಗಳು ಬಂದಿದೆ. ಇದು ನ್ಯಾಯಾಂಗದ ಮೇಲೆ ನಮ್ಮ ವಿಶ್ವಾಸವನ್ನ ಹೆಚ್ಚಿಸ್ತಾ ಇದೆ ಮತ್ತೆ ಅನ್ನುವಂಥದ್ದನ್ನ ಅವರು ನಮ್ಮ ಗಮನ ಸೆಳೆದಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಚುನಾವಣಾ ಬಾಂಡ್ ವ್ಯವಸ್ಥೆ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದಾರೆ. ಇದನ್ನ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ನ ಪೀಠ ಅಸಂವಿಧಾನಿಕ ಅಂತ, ಚುನಾವಣಾ ಬಾಂಡ್ಗಳು ಅಸಂವಿಧಾನಿಕ ಅಂತ ಈಗಾಗಲೇ ಘೋಷಿಸಿದೆ. ಇದನ್ನು ಏನ್ ಮಾಡಬೇಕು, 2017ಕ್ಕಿಂತ ಮೊದಲಿದ್ದ ವ್ಯವಸ್ಥೆ ಸರಿ ಇದೆಯಾ ಅಂದ್ರೆ ಅದು ಕೂಡ ಅಷ್ಟೊಂದು ಸೂಕ್ತವಾಗಿಲ್ಲ, ಸಮರ್ಪಕವಾಗಿಲ್ಲ. ಅದರ ಬದಲಾಗಿ ರಾಷ್ಟ್ರೀಯ ಚುನಾವಣಾ ನಿಧಿ ಅಂತ ಸ್ಥಾಪಿಸೋಣ. ಅವಶ್ಯಕತೆ ಇರೋರು ಎಲ್ಲರೂ ಕೂಡ ಅದಕ್ಕೆ ಕಾಂಟ್ರಿಬ್ಯೂಟ್ ಮಾಡ್ಬೋದು, ಹಣವನ್ನು ನೀಡ್ಬೋದು. ಸೊ ಆ ಮೂಲಕ ಒಂದು ಪಾರದರ್ಶಕತೆಯನ್ನ ಮತ್ತೆ ಜನರಲ್ಲಿ ಒಂದು ಹೊಣೆಗಾರಿಕೆಯನ್ನ ತರಬಹುದು. ಸೊ ಜನರಲ್ಲಿ ಹೊಣೆಗಾರಿಕೆ ಮತ್ತೆ ಸರ್ಕಾರದ ಹಂತದಲ್ಲೂ ಕಾರ್ಯಾಂಗದ ಹಂತದಲ್ಲೂ ಹೊಣೆಗಾರಿಕೆ ಬಂದ್ರೆ ಚುನಾವಣಾ ವ್ಯವಸ್ಥೆ ಹೆಚ್ಚು ಸೂಕ್ತವಾಗಿ ನಡೀತದೆ ಮತ್ತು ಹೆಚ್ಚು ಪ್ರಜಾಪ್ರಭುತ್ವೀಯ ಮಾದರಿಯಲ್ಲಿ ನಡೀತಿದೆ. ಸೊ ಇಂತಹ ಒಂದು ಅವಕಾಶನ ಕಡೆಗೆ ನಾವು ಚರ್ಚೆ ಮಾಡಬೇಕು, ಯೋಚಿಸಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಇದು ಇವರು ಮಾತನಾಡೋ ವಿಷಯದ ಬಗ್ಗೆ ಒಂದು ಸಂಕ್ಷಿಪ್ತವಾಗಿ. ಥ್ಯಾಂಕ್ ಯು.
Thank you for that. Dr. Sridharan, would you like to go there? Okay. I'll intervene in 9 minutes or so.
Let me first thank the National Law School and the Government of Karnataka for this invitation. I've been given this panel of speaking on the institutional guardrails of democracy. So in the next 10 minutes or so, I'll basically try to set this in a larger global context of the quality of democracy debate, building upon a chapter of mine which is coming out in a Oxford University Press UK volume later this year on comparative quality of democracy around the world, in which I did the India chapter, and I analyzed the reports of the international democracy rating agencies. I mean, Freedom House, Economist International Intelligence Unit, and VDEM of Sweden. And I'll build on that chapter, and also build on an idea which Professor Ashutosh Vashne, who is here, put forward in an article about 25 years ago. Now, let me first talk about the institutional guardrails. I mean, Professor Aparna Chandra and Dr. Qureshi have spoken extensively about the fourth branch institutions, what are called the institutions of horizontal accountability. That is lateral accountability, constitutional or statutory institutions which monitor the quality of democracy, broadly speaking, if one can call it that. And we've heard about the Judiciary and the Election Commission in great detail. The other, in the Indian context, the other horizontal accountability institutions would be the CAG, the Controller and Auditor General, the Central Vigilance Commission, the Central Information Commission, which implements the Right to Information Act of 2005, and the Lokpal, and at the state level, the Lokayuktas, Anti-Corruption Commission. So these are the horizontal institutions of horizontal accountability, which can be considered the institutional guardrails of democracy, broadly speaking. And there are equivalents around the world in many countries to these institutions. Now, the question I'm trying to put this in the context of the quality of democracy debate internationally. If you look at the quality of I'm sort of building upon Larry Diamond and Leonardo Molino, their seminal article about 20 years ago. Now, the quality of democracy can be divided. There are basically 8 characteristics or 8 features which assess or measure the quality of democracy, and they can be divided into 3 subcategories. There are the quality of procedure, that is, the quality of democracy can be divided into quality of procedure. The second lot is the quality of substance or content of democracy, and the third lot is the quality of the results of democracy, okay, or the outputs of democracy. Now, if you look at the quality of procedure, there are 5 of these 8 characteristics fall within this. One is the rule of law. Second is participation, measured typically by turnout, voter turnout. Then there is competition. I mean, can a range of parties and views compete in the electoral arena on free and fair basis? Then there is what are called the vertical accountability, which is at 2 levels. It can be considered accountability of the political executive to parliament, which means that the powers of the opposition and also the powers of the legislators of the ruling party or coalition to hold the political executive accountable. Now, and the fifth are the institutions of horizontal accountability, which we have seen are, I just listed them, there are 5 of them in the Indian context, and they can in principle be more also. And these are lateral institutions, constitutional or statutory, which monitor the functioning of the government inter-election. And then the second part of the quality of democracy is the characteristics which measure the substance or content of democracy. That is basically the civil and political liberties, the political rights and civil rights, freedoms that are guaranteed in the Constitution. And then there is the right to equality and the political equality, socio-economic equality, etc. So freedom and equality constitute the substance or content of democracy. That is one of the 3 quality subcategories. The third subcategory of the quality of democracy would be what's called the quality of the results or output of democracy. That is the policy benefits, the policy outcomes, outputs, and how they are received by the public. I mean, how the consumer, the voter, receives the policy outputs. Now, in the international assessment of the last few years of these 3 major rating agencies of democracy, Indian democracy has not been faulted on account of vertical accountability, at least as far as elections goes. There have been 1 or 2 remarks about implementation of model code, but basically the results, unlike in a range of countries, are not seen as unfair or rigged. The results are seen as valid. Free and fair elections with competition. There are over 30 parties represented in parliament in the last 2 elections at least, and going back before that also. So there is competition, there are free and fair elections, and the best test of the results is that the opposition, the losing side in the central and state elections, accepts the verdict. So Indian democracy has not been criticized as far as elections goes. What has been criticized in these rating agency reports is the quality of substance or content, that is inter-election. What happens to rights and liberties? That has been criticized in various ways. I don't have time to go into that. But the criticism is about inter-election conduct and rights and liberties, and not about the validity of elections. Now, the third thing about the quality of the results, in fact, one argument can be made that vertical accountability, at least the government to the voters, is going up because the standard measure of participation and competition, there are 30 parties plus 35 parties plus in parliament, and voter turnout was highest ever in 2014, still higher in 2019. So if anybody wants to make that argument, if going only by participation, voter turnout is increasing. So, that argument can be made that actually democracy is deepening and voter turnout is increasing. But we have also seen in a range of countries that you can have voter turnout and mass support for a government or for any party or coalition, and you can also have widespread curtailment of civil liberties and so on at the same time. There are a number of countries like that. The term electoral autocracy, which I don't agree with in the Indian context, has been applied by VDEM to India. I don't agree with that. But there is enough participation and competition, and including federalism. There's a dispersion of power. But in many countries, like Hungary or Turkey, for example, there is what's called electoral autocracy. So now, going back to the quality of democracy, so you have quality of procedure, procedural issues, then, rule of law, etc., participation, competition, vertical and horizontal accountability. You have quality of substance or content, that is rights and liberties and equality. And you have quality of results, that is how does the voter, the consumer, receive the political or policy outputs of democracy. Now, here I would like to, say a few words about horizontal accountability, that we do have institutions of horizontal accountability, both constitutional and statutory. Now, if they are statutory, the president can, the way in which the members of these commissions are appointed and how they can be removed is vital. The statutory ones, the president can remove them, like the CVC, the CIC and the Lokpal, and the constitutional ones like CAG and ECI, which Dr. Qureshi has talked about, and the judiciary, which Dr. Chandra has talked about, are, you can be removed only by impeachment. And so those are more able to monitor horizontally the inter-election behavior. Now, I'm coming to something a bit larger than that, that is, to what extent, two more things I'll say in my few remaining minutes. One is that what is being guarded? Institutional guardrails guard something. So what is being guarded? And here I will say the problem of rights and liberties, democratic rights and freedoms, freedom of speech and expression, of association, assembly, residence, movement, occupation, etc. These are something which have been qualified in much earlier. What is being guarded or being monitored is something, actually a regime of rights which has been already qualified in significant ways well before the last 5 years or well before the last 10 years. In 1951, the First Amendment introduced so-called reasonable restrictions on the right to speech and expression, which have 8 different things which are supposedly reasonable restrictions, which include security of the state, very broadly defined, relations with foreign states, which is extraordinary, public order, very broadly defined, decency, morality, incitement to an offense. All these things are very broadly defined and highly discretionary. Similarly, in the IPC, Indian Penal Code, we have the hate speech, so-called hate speech laws, that is 153A, 295A, 4505, which are also very broadly defined and discretionary. And likewise, you have, the UAPA, which is 1967, and then, amended in 2019, and you have the National Investigation Agency set up in 2008, amended again in 2019, and those amendments, those making the UAPA and the NIA more in the language more strict, more tight, and more easy for the government to pursue somebody, were passed with the opposition going along in the Rajya Sabha. So we are talking about something, which we are talking about a regime. So when you're talking about institutional guardrails, my point is, what are they guarding? They're guarding a discretionary system of a very broadly discretionary system of intervention by the state, of more qualified, a regime of qualified rights, right from the First Amendment 1951, which qualified the right to freedom of free speech and expression. So what is being guarded by the guardrails, by these horizontal accountable institutions, is a compromised regime of rights. I mean, I'm looking at it globally, where these compromises happened before the last 10 years. It's coming from a long time back. And even the tightening in 2019 was accepted by the opposition in the Rajya Sabha. So I think if we are to go towards a strengthened and less discretionary regime of rights and liberties, we have to have some kind of an all-party consensus. Like there's an example already in the model code of elections is an all-party consensus. It'll have to be something like that. It can't be just by this party or coalition, that party or coalition. It has to be a broad consensus to reduce the qualifications on fundamental rights and the discretionary nature of interventions where any government, not of any party, can undertake. What is being guarded by the guardrails is as important as the guardrails themselves. That's my point. And lastly, I'd like to say, just my last point is about going back to the quality of democracy. Now, here I'm borrowing from Ashu's point when he talked about elite politics and mass politics. Now, if the masses, the voters, care only about the quality of results, about the output they're getting, the policy benefits, and they don't care about quality of procedure, rule of law, etc. rights, if they don't care about content, rights and equality, if those are elite things, if those are things which the elites care about, I mean, the quality of procedure, the 5 things under that, the quality of substance of content, the rights and rights to liberty and equality, if they don't care that much, if those are elite concerns, and if mass concerns are only about the quality of the results of democracy, the policy outputs, what they get, then we are in trouble. Then any democracy is in trouble. And you can see this globally also. Quality of results can be delivered. You don't even have to be a democracy. You can be China, which delivered 40 years of record growth. Record growth, and people accept it. I've been to China 12 times in 12 years before the pandemic, going to 7-8 places, many campuses. People, the middle class, the elite, they accept the system. I mean, and they don't try to defect. They go in large numbers, 150 million going abroad. They come back. I mean, there are more PhD students in the US who go back to China than go back to India. And so they accept the system. I mean, people are looking at this is a case of the quality of the results being matter, not quality of content of democracy. Of course, it's not a democracy, or quality of procedures, of, monitoring the functioning of democracy. People at the mass level, if what Ashu said, if you apply that to the quality of democracy literature, and the quality of procedure and content are just elite concerns, and if mass concerns are about the quality of output, results, then we can be in trouble. I mean, democracies anywhere can be in trouble, and authoritarian regimes can also produce results. China is the best example. And authoritarian regimes, as we know historically, can have mass support. I mean, 1930s, fascism had mass support. If people don't care about the quality of procedure and content, but only about results, then democracies can be in trouble. Yeah, so I'll just sign off there. Thank you so much.
ಡಾಕ್ಟರ್ ಇ ಶ್ರೀಧರನ್ ಸರ್ ಅವರು ಪ್ರಜಾಪ್ರಭುತ್ವದ ವ್ಯವಸ್ಥೆಯ ಉಳಿವಿಗೆ ಇರುವಂಥ ಪ್ರಜಾಪ್ರಭುತ್ವದ ಗುಣಮಟ್ಟ ಅಳೆಯುವ ಮಾನದಂಡಗಳ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದಾರೆ. ಕ್ವಾಲಿಟಿ ಆಫ್ ಡೆಮಾಕ್ರಸಿ ಕ್ಯಾನ್ ಬಿ ಮೆಜರ್ಡ್ ಅಂತ. ಆ ಮಾನದಂಡಗಳನ್ನು ಮೂರು ಹಂತಗಳಲ್ಲಿ ನೋಡೋ ಪ್ರಯತ್ನ ಮಾಡಿದ್ದಾರೆ. ಒಂದು, ಕ್ವಾಲಿಟಿ ಆಫ್ ಪ್ರೊಸೀಜರ್, ಪ್ರಕ್ರಿಯೆಯ ಗುಣಮಟ್ಟ, ಪ್ರಜಾಪ್ರಭುತ್ವವನ್ನು ಉಳಿಸಿಕೊಳ್ಳುವಂತಹ ನಡೆಸಿಕೊಂಡು ಹೋಗುವಂತಹ ಪ್ರಕ್ರಿಯೆಯ ಗುಣಮಟ್ಟ. ಸಬ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಕಂಟೆಂಟ್, ವಿಷಯ ವಸ್ತುವಿನ ಗುಣಮಟ್ಟ, ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆ ಒಳಗೆ ಇರುವಂತಹ ವಿಷಯ ವಸ್ತುವಿನ ಗುಣಮಟ್ಟದಲ್ಲಿ. ಮತ್ತೊಂದು ಫಲಿತಾಂಶಗಳ ಗುಣಮಟ್ಟ, ಕ್ವಾಲಿಟಿ ಆಫ್ ರಿಸಲ್ಟ್ಸ್ ಅಂತ ಮಾತಾಡ್ತಾ ಇದ್ದಾರೆ. ಮೊದಲನೇದಾಗಿ ಪ್ರಕ್ರಿಯೆಯ ಗುಣಮಟ್ಟದಲ್ಲಿ ಮತದಾನ ಆಗ್ತಿರುವಂತಹ ಪ್ರಮಾಣ, ಪಕ್ಷಗಳಿರುವಂತಹ ಸಂಖ್ಯೆ ಮತ್ತು ಅವುಗಳಿರುವಂತಹ ಪ್ರಾತಿನಿಧ್ಯತೆ, ಮತ್ತೆ ಸಮಾನಾಂತರವಾಗಿರುವಂತಹ ಉತ್ತರದಾಯಿತ್ವ ಮತ್ತು ಲಂಬಾಕೃತಿಯಲ್ಲಿ ಇರುವಂತಹ ಉತ್ತರದಾಯಿತ್ವ, ಅಂದ್ರೆ ವರ್ಟಿಕಲ್ ಮತ್ತೆ ಹಾರಿಜಾಂಟಲ್ ಅಕೌಂಟಬಿಲಿಟಿಗಳ ಬಗ್ಗೆ. ಮತ್ತೆ ಮುಂದೆ ಎರಡನೇ ಭಾಗವಾಗಿ ಸಬ್ಸ್ಟೆನ್ಸ್ ಆಫ್ ಕಂಟೆಂಟ್, ವಿಷಯ ವಸ್ತುವಿನ ಗುಣಮಟ್ಟದಲ್ಲಿ ನೋಡಿದ್ರೆ ನಾಗರಿಕ ಹಕ್ಕುಗಳು ಮತ್ತೆ ಮೂಲಭೂತ ಹಕ್ಕುಗಳ ಬಳಕೆ ಮತ್ತು ಅವುಗಳನ್ನ ನಡೆಸ್ಕೊಂಡು ಹೋಗ್ತಿರುವಂತಹ ರೀತಿಯ ಬಗ್ಗೆ ಮತ್ತೆ ಬಳಸ್ತಿರುವ ರೀತಿಯ ಬಗ್ಗೆ ಮಾತನಾಡಿದ್ದಾರೆ. ಮೂರನೇದು ಫಲಿತಾಂಶಗಳ ಗುಣಮಟ್ಟದಲ್ಲಿ ನೋಡಿದ್ರೆ ನೀತಿ ನಿಯಮಾವಳಿಗಳು ಜನರಿಗೆ ನೀಡ್ತಿರುವಂತಹ ಫಲಗಳೇನು ಮತ್ತೆ ಅವು ಫಲಿತಾಂಶಗಳೇನು, ಅವುಗಳ ಯಶಸ್ಸಿನ ಪ್ರಮಾಣಗಳೇನು ಅನ್ನೋದು ಮೂಲಕ ನೋಡ್ತಾ ಇದ್ದಾರೆ. ಸೊ ಇದಕ್ಕೆ ಈ ಮೂರು ಹಂತಗಳಲ್ಲಿ ಇರುವಂತಹ ಈ ಫಲಿತಾಂಶಗಳ ಮೂರು ಹಂತಗಳಲ್ಲಿ ಇರುವಂತಹ ವ್ಯತ್ಯಾಸಗಳನ್ನ ನಾವು ಚರ್ಚೆಗೆ ಒಳಪಡಿಸಬೇಕು ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅಂದ್ರೆ ಪ್ರಭುತ್ವ ಸ್ವಾತಂತ್ರ್ಯ ಬಂದ ದಿನದಿಂದಲೂ, ಕಳೆದ 10 ವರ್ಷದಲ್ಲಿ ಮಾತ್ರ ಅಲ್ಲ, ಸ್ವಾತಂತ್ರ್ಯ ಬಂದ ದಿನಗಳಿಂದಲೂ ಪ್ರಭುತ್ವ ಈ ಮೂರು ಪ್ರಕ್ರಿಯೆ ಗುಣಮಟ್ಟ, ವಿಷಯ ವಸ್ತುವಿನ ಗುಣಮಟ್ಟ ಮತ್ತು ಫಲಿತಾಂಶಗಳ ಗುಣಮಟ್ಟದ ಮೇಲೆ ನಿಯಂತ್ರಣವನ್ನ ನಿಧಾನವಾಗಿ ಹೇರ್ತಾ ಬರ್ತಾ ಇದೆ. ಅದು ಇನ್ನ ಹೆಚ್ಚಾಗ್ತಾ ಹೋಗ್ತಾ ಇದೆ. ಇದ್ರ ಈ ನಿಯಂತ್ರಣ ಮಾಡ್ತಿರುವುದ್ರ ಕುರಿತು ಚರ್ಚೆ ಆಗ್ಬೇಕು, ಅದ್ರ ಕುರಿತು ಹೋರಾಟಗಳು ನಡಿಬೇಕಂದ್ರೆ ಕೃತಿಗಿಳಿಯುವಂತ ಕೆಲಸಗಳು ನಡಿಬೇಕು, ಬರೀ ಚರ್ಚೆಯಲ್ಲಿ ಉಳಿಬಾರ್ದು. ಸೊ ಹಾಗಾದಾಗ ನಾವು ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆಯನ್ನು ಉಳಿಸ್ಕೋಬಹುದು, ಅದರ ಗುಣಮಟ್ಟ, ಪ್ರಜಾಪ್ರಭುತ್ವ ಗುಣಮಟ್ಟವನ್ನು ಉಳಿಸ್ಕೋಬಹುದು. ಇನ್ನೊಂದು ಮುಖ್ಯವಾಗಿ ಮತದಾರರು ಅಂದ್ರೆ ಜನರು ಕೇವಲ ಮೂರನೇ ವಿಷಯದ ಮೇಲೆ ಮಾತ್ರ ಗಮನ ಕೊಟ್ರೆ, ಮೊದಲ ಎರಡು ವಿಷಯಗಳ ಕಡೆಗೆ ಗಮನ ಕೊಟ್ರೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆ ಸೋಲ್ತದೆ ಅಂತ ಹೇಳ್ತಿದ್ರು. ಅಂದ್ರೆ ಫಲಿತಾಂಶಗಳ ಗುಣಮಟ್ಟ, ಯೋಜನೆಗಳು ನಮಗೆ ಎಷ್ಟು ಫಲ ಕೊಡ್ತಾ ಇದಾವೆ ಅನ್ನೋದ್ರ ಬಗ್ಗೆ ಮಾತ್ರ ಗಮನ ಕೊಟ್ರೆ, ಆ ಯೋಜನೆಗಳು ಹೇಗೆ ತಲುಪ್ತಾ ಇದಾವೆ, ಅವುಗಳನ್ನು ಹೇಗೆ ರೂಪಿಸಲಾಗಿದೆ, ಅವುಗಳ ಪ್ರಮಾಣ ಏನು ಅನ್ನೋದನ್ನ ಮರೆತ್ರೆ ಸೊ ಮತ್ತೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆಯನ್ನ ಗುಣಮಟ್ಟದಿಂದ ಕಾಯ್ದುಕೊಂಡು ಹೋಗೋದ್ರಲ್ಲಿ ನಾವು ವಿಫಲರಾಗ್ತೀವಿ. ಹಾಗಾಗಿ ಮೊದಲ ಎರಡು ವಿಷಯಗಳೇನಿದೆ, ಪ್ರಕ್ರಿಯೆ ಗುಣಮಟ್ಟ ಮತ್ತೆ ವಿಷಯ ವಸ್ತುವಿನ ಗುಣಮಟ್ಟ, ಅದ್ರ ಕಡೆ ಗಮನ ಕೊಡ್ಕೊಂಡು ಮೂರನೇ ವಿಷಯ ಕಡೆಗೆ ಗಮನ ಕೊಟ್ರೆ ಹೆಚ್ಚು ಜನರು ಕೂಡ ಉತ್ತರದಾಯಿಯಾಗಿರ್ತಾರೆ, ಅವರ ಜವಾಬ್ದಾರಿಯನ್ನು ನಿರ್ವಹಿಸಿದಂತಾಗ್ತದೆ, ಒಟ್ಟಾರೆ ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆ ಉಳಿಯುತ್ತೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
ಥ್ಯಾಂಕ್ ಯು. Professor Thiruvengadam will speak now. Thanks.
Thank you, Professor Lamba. Good morning, and I want to start by thanking the organizers for providing me the opportunity to speak to you. I should say it's been a very interesting experience to sit through the presentations yesterday. I'm very happy to see that there's so many young people in the audience. As the other speakers have alluded to, we live in a time when constitutional democracy is seen as being in a crisis. Many of us work on these issues as academics, as people who've been in important institutions in the country, whether as Dr. Qureshi has been a chief election commissioner. There are others in the audience who've worked in government, and there are many of us who are ordinary citizens who are thinking of these questions and trying to find ways out. So we've been part of a very interesting panel, as Professor Chandra set the tone by discussing broadly what institutions are supposed to do in constitutional democracies. What I will try and do, and we had a brief discussion amongst us in what would be the most productive way to hopefully also spur a discussion. We hopefully will have about 25 to 30 minutes for a discussion. So what I will do in my 8 or 9 minutes that I have left is three things. In the first panel, Professor Krishna also said the theme of these set of 5 sessions is to assess the working of the Constitution of India of 1950. And our panel is particularly looking at constitutional institutions. And as all the panels have done, what we have tried to do is what was the constitutional design in 1950, what has been the practice across these 75 years. So on my first point, I'll say a little bit to complement what others have said. On the second point, and Dr. Sridharan referred to this general sense that democracy and constitutional democracy is under threat. So I'll talk a little bit about that. And again, Dr. Qureshi said hope is not a strategy, but hope is very important. And I'm, instead of looking at many constitutional systems which are struggling or failing, I'm going to draw attention to what happened in Poland. And the Polish case is really interesting because it's one of the few cases where in the midst of a sense of constitutional crisis over almost a decade, from 2015 to 2023, the Polish coalition and forces that work towards democracy managed to win an election in October 2023 and are now engaged in a process that a scholar has called constitutional repair. And I think that case is actually quite interesting. I'll try and draw attention to a specific context of Poland in the hope of having a concrete situation that we can discuss. And finally, the third point will be what is it that we can do in India as we talk about sustaining a constitutional democracy. I think that's really the subject matter of the next panel and also the discussion that we will have. But I'll put out a couple of thoughts that many scholars have suggested. So on the first point of how do we assess the institutional safe guardrails of democracy. So as both Professor Chandra and Professor Sridharan have spoken about, there are many ways of characterizing these institutions. I think it's generally regarded as the Constitution of India. And in other panels, people have said why the Constitution of India of 1950 was quite remarkable in what it did, given what was the thinking about constitutional institutions in 1950. So the institutions that are referred to as fourth branch or guarantor institutions, Professor Chandra mentioned my own preference is for what the South African Constitution in Chapter 9 says, state institutions that support democracy. And I think that's one way to think of it. But the South African Constitution is drafted in the mid-90s. It actually takes a lot of inspiration from the Constitution of India of 1950, which doesn't have a specific chapter on these institutions. These institutions are scattered across the text of the Constitution. But if you think about it, there's been a lot of thinking about how these institutions can work, right? So as Professor Chandra said, you have the classic division of powers between the executive, the state, the legislature, and the judiciary. This idea of separation of powers. We know that classic separation of powers fails to work in any system. So in the United States, scholars who looked at the idea of separation of powers in the early 2000s said the United States has a separation of parties, not powers. And I think that situation applies to many other countries as well. Most constitutions, the classic constitutions, could not anticipate the rise of political parties. Most classical constitutions don't actually regulate political parties. By the mid-20th century, the German constitution tries to do this through this concept of militant democracy. And you can see it working out right now as the German constitutional system tries to think about the AfD. And how do you regulate a party which is anti-constitutional, right? There's some debate about that, whether the remedy could be worse than the cure, but that context is something quite significant. So one of the failings of the Indian constitution, which could have looked at what Germany was doing, is that we don't regulate political parties formally in the constitution. Now, Dr. Qureshi talked about measures that have been done later on. Dr. Sridharan said there's things in the constitutional design, and then there are statutory attempts later on to try and address it. But clearly, as the electoral bonds case points out, as earlier attempts like the Model Code of Conduct also shows, these are not functioning in a context where political parties have become overly dominant and can avoid and work around constitutional mechanisms and legal mechanisms. So that's one. We've talked about the Election Commission. Dr. Sridharan mentioned the office of the CAG in India, the Comptroller and Auditor General. This was also a very innovative idea, much before other institutions were doing. I'll mention a few more, which we don't think of as guarantor institutions, but are actually quite significant. When you think about in 1950, Clearly, elections were going to be very important, but the framers were thinking about multiple other institutions to try and think about how do you preserve this constitution, which has been, and Professor Krishna mentioned, we don't talk about this enough, but this was after a struggle for almost a century, right? So the framers were really thinking about what are the ways we can safeguard that democracy. So some institutions I would mention, apart from the ones that have been talked about, is the Union Public Service Commission. Right? There are 6 provisions of the Constitution which deal with that. Yesterday in the federalism panel, Dr. Yamini Iyer talked about how the system of dual accountability of the civil services has been eroded consistently for several decades now, right? But perhaps more so in the last decade. And the UPSC is a mechanism the framers thought about in 1950 to try and ensure that the integrity of the civil services could be protected, right? Similarly, there are other bodies. The Finance Commission was talked about yesterday. I think in the federalism panel, Dr. Rao mentioned that we don't have institutions for interstate coordination. The Constitution does envisage the concept of an interstate council. Later on, through statutes, when we have interstate river water disputes, constant concern in many states. Karnataka and Tamil Nadu have been at loggerheads about that. The idea of an interstate water commission created statutorily, but there's been a demand also perhaps to give it constitutional entrenchment, right? So across a range of issues, the framers of our constitution thought of having institutions which would be somewhat insulated from ordinary political pressures of the day. In that sense, the Indian constitution was really well ahead of its time, and many other constitutional systems, the South African constitution being mentioned, is one of those. In South Africa, there are 6 institutions that are mentioned in Chapter 9. And it'll be interesting to look at those institutions. They have the idea of a public protector, which deals with public administration, the South African Human Rights Commission, a commission for protection of cultural, religious, and linguistic rights, a commission for gender equality, and then 2, which arguably they've taken from the Indian context, an Auditor General and an Election Commission, right? So the idea of thinking about institutions, so when you think of constitutional design, we already have institutions in our constitution right from 1950, and then Parliament also created. So in India, we didn't have a National Human Rights Commission in the constitution. That comes up in the 1990s. I'm going to also suggest that there are other institutions that can be considered on a similar analytical sort of front. Since 1991, we have about between 25 and 30 regulatory institutions. So you think about SEBI and TRI in the Indian context. These are regulatory institutions created very often by statute, but they also perform this role of combining. And Dr. Sridharan said, what are we guarding against? Well, we are guarding against majoritarianism, populism, but we are also guarding against important technical decisions, technocratic decisions being taken by political considerations alone. So the idea of embedding technocratic competence in institutions is also a very important way of looking at these. So I think on those fronts, when we now try and do an assessment of the Indian Constitution, and Dr. Qureshi talked about how, despite that kind of vision, there are clear problems in, say, the field of electoral law that our system hasn't done very well about. Right? How do you regulate the entry of people with criminal backgrounds into politics? He raised the important issue of so many people who are detained, what happens to their rights to vote or to stand for election. Similarly, if you go into all these issues that I've mentioned, you could come across many sort of failings that are there across governments, right? Across our 75 years of practice. But across the last 10 years, there's been a sense that Indian constitutionalism is under a great threat, right? This part, I'll just now move to Poland. I'll rely on the work of one scholar, Professor Sadurski, who has consistently written about constitutional democracy in Poland. So Poland, as some of you may know, is a relatively small compared to us, but within the European Union, it's a fairly large country. It's the 5th largest country with 38 million people. It's, I think, the 6th largest economy in the European Union. Since 2015, Poland has experienced, let's call it authoritarianism, through a party which is somewhat ironically called the Law and Justice Party, or PiS as it is referred to in Poland. And since for 8 years, that party came to power through regular elections, but then started a massive assault on the Polish constitution. So Professor Sadurski uses Poland. He has a very insightful book, which I read because of concerns about what is happening in India. It's called The Constitutional Breakdown in Poland. And in the final chapter of his book, he identifies 10 strategies that the Peace Party employed in Poland. I'm going to read out these 10 strategies because I'm going to suggest to you that these strategies should be familiar to constitutional democracies around the world. We've talked about Hungary, Poland, you think about Turkey, you think of the United States and the United Kingdom also. And let's just very briefly look at these 10 points. First, depicting the opposition as disloyal and demonizing critics as illegitimate, unpatriotic, and out of touch with quote-unquote real people. Second, attacking courts' independence with special emphasis on dismantling the Constitutional Court and reinventing it as the executive's faithful ally. Third, weakening and demonizing the independent media, mobilizing public opinion against an independent press as expressing the old elite's interests and views, discouraging advertising in independent media to weaken their economic base, supporting friendly private media. Fourth, capturing and politicizing public media, turning them into government's propaganda machine, providing them regularly with fake or true compromising materials on the government's critiques. Fifth, intimidating civil society and support for government-friendly, non-governmental organizations. Sixth, politicizing the civil service, law enforcement and security apparatus. Seventh, engaging in a generous policy of spoils and patronage for party faithfuls and supporters. Eighth, gaining control of the electoral administration, packing the electoral institutions with party loyalists or persons dependent on the executive branch. Ninth, redesigning the contours of the freedom of assembly and freedom of speech, penalizing speech that undermines the nationalistic propaganda. And 10, playing a game of cat and mouse with supranational attempts at monitoring, criticizing, and policing transgressions of the rule of law and democracy.
So
I'm going to suggest to you...
I will intervene now.
just coming to the last part, I mentioned these 10 points just to say that these are threats to constitutional democracy, not just in Poland, which is what Professor Sadurski is talking about, but in many old established constitutional democracies of the world. So the question that Professor Sadurski says is, what do we do in response? He wrote this book in 2019. Many of the Polish political parties seem to have taken heed from what he had to say, and Poland is now going through a process, a very difficult process. In Poland, a coalition of progressive constitutionalist parties headed by Donald Tusk defeated the Peace Party, but they are now, and if you follow the news for the last 2 weeks, experiencing many challenges in trying to restore constitutional democracy. Now, what can be done? Well, one thing, and I think we can see many political parties engaged in that, is try to win elections, right? So the way to beat political parties is to beat them at the hustings and come to power. That's not going to solve problems because the erosion and corrosion of constitutional institutions and values will take time, and Poland in the last 6 months is really struggling to go that because the president of Poland is still someone who was appointed by the Peace Party. So many institutions in Poland still have peace loyalists in them, so it's going to be a long, hard struggle. Now, in countries where you haven't got that situation, and I think a lot of people in the panels yesterday, and I'm sure in the panel later, are also thinking about what is happening. Professor Krishna mentioned that perhaps one failing of the Indian constitution is it is so focused on the Indian state, it's not focusing on the Indian nation. So clearly, in our contemporary debate, we are having a massive debate about what does the Indian nation connote, right? What does it stand for? Professor Khaitan yesterday said we have to come across, if Hindutva is the reigning ideology today, we have to come across with solutions to what could be alternatives. It can't just be that we keep going back only to the constitution. I found his idea of Hindustaniyat very interesting. He put out certain qualities of what is it that you would build an alternative platform to combat the reigning ideologies of the day. Now, I'll just end with this. We are talking about institutions, and usually political scientists and constitutional scholars focus on this. But the challenge, and looking across the panels in this conference, is actually very interesting, because you see that there are a range of social activists, independent press persons, independent-minded politicians who are not completely captured by one or the other political regime, right? So the idea of independent citizens acting in the political process, either as nominated members of the houses which Parliament does provide for, I think that's going to be a challenge, and I think that's going to be a much longer battle that will have to be engaged beyond just the next election or the next election cycle, right? So I'll leave you with that thought, and I look forward to a discussion of what could be done on that in this and the next session. Thank you very much.
Thank you.
ಪ್ರೊಫೆಸರ್ ಅರುಣ್ ಸರ್ ಅವರು ಪ್ರಜಾಪ್ರಭುತ್ವವನ್ನು ಉಳಿಸುವ ನಿಟ್ಟಿನಲ್ಲಿ ಯಾವ ರೀತಿಯಾಗಿ ಬೇರೆ ಬೇರೆ ದೇಶಗಳು ತಮ್ಮ ಸಂವಿಧಾನಗಳ ಮೂಲಕ ಕೆಲಸಗಳನ್ನು ಮಾಡ್ತಾ ಇದೆ ಅನ್ನೋದು ಉದಾಹರಣೆಗಳ ಮೂಲಕ ವಿವರಿಸಿದ್ದಾರೆ. ಅದರಲ್ಲಿ ಮುಖ್ಯವಾಗಿ ಶಾಸಕಾಂಗ, ಕಾರ್ಯಾಂಗ ಮತ್ತು ನ್ಯಾಯಾಂಗದ ಅಧಿಕಾರ ಹಂಚಿಕೆ ತುಂಬ ಆದರ್ಶಮಯವಾಗಿ ನೋಡಿರುವಂಥ ದೇಶಗಳು ಮತ್ತು ಆ ದೇಶಗಳ ಸಂವಿಧಾನಗಳು ಬಹುತೇಕ ಕೆಲವು ಹಂತದಲ್ಲಿ ಸೋಲನ್ನು ಕಂಡಿದ್ದಾವೆ. ಸೊ ಅದಕ್ಕಾಗಿ ಆ ದೇಶಕ್ಕೆ ಅನ್ವಯವಾಗುವಂತೆ ಅದರ ಸ್ಕೋಪ್ ಅಥವಾ ಸ್ಪಿರಿಟಿಗೆ ಅನ್ವಯವಾಗುವಂತೆ ಯಾವ ರೀತಿಯಾಗಿ ನಾವು ಆ ಒಂದು ನಿಯಂತ್ರಣವನ್ನು ಮಾಡಬೇಕಂತ ನೋಡಬೇಕಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಒಂದು ಉದಾಹರಣೆಯಾಗಿ ಜರ್ಮನಿಯಲ್ಲಿ ಸಂವಿಧಾನದ ಮೂಲಕ ರಾಜಕೀಯ ಪಕ್ಷಗಳನ್ನು ಹೆಚ್ಚು ನಿಯಂತ್ರಣಕ್ಕೊಳಪಡಿಸುವಂಥ ಪ್ರಕ್ರಿಯೆ ನಡೀತಾ ಇದೆ. ಆದರೆ ಭಾರತದಲ್ಲಿ ಅದು ಆಗ್ತಾ ಇಲ್ಲ. ಸೊ ಅದು ಒಂದು ಸಮಸ್ಯೆ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದಕ್ಕೆ ಉದಾಹರಣೆಯಾಗಿ ಕೇಂದ್ರ ನಾಗರಿಕ ಸೇವಾ ಆಯೋಗ ಇರ್ಬೋದು, ಅಂತಾರಾಜ್ಯದ ಗಡಿಗಳು ಮತ್ತು ಅಂತಾರಾಜ್ಯದ ನೀರು ಹಂಚಿಕೆಗಳು, ಸೆಬಿ ಇರ್ಬೋದು, ಟ್ರಾಯ್ ಇರ್ಬೋದು, ಇವು ಎಲ್ಲವುಗಳ ಕಾರ್ಯನಿರ್ವಹಣೆ ಮತ್ತು ಅವುಗಳ ನಿಯಂತ್ರಣದ ವಿಷಯದಲ್ಲಿ ಕೇಂದ್ರ ಹೆಚ್ಚು ಅಧಿಕಾರವನ್ನು ಪ್ರಯೋಗಿಸ್ತಾ ಇದೆ, ತನ್ನ ಹಿಡಿತದಲ್ಲಿ ಇಟ್ಕೊಂಡಿದೆ. ಅದು ಹಿಂದಿನಿಂದನೂ ನಡೆದು ಬಂದಿತ್ತು. ಆದರೆ ಕಳೆದ 10 ವರ್ಷಗಳಲ್ಲಿ ಒಂದು ಅಧಿಕಾರ ಇನ್ನೂ ಹೆಚ್ಚು ಕೇಂದ್ರೀಕೃತ ಆಗ್ತಾ ಇದೆ ಮತ್ತು ಭಾರತದ ಸಂವಿಧಾನವೇ ಅಪಾಯದಲ್ಲಿದೆ ಅನ್ನೋ ಒಂದು ಭಾವನೆ ಬರ್ತಾ ಇದೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಇದ್ರ ಮುಂದುವರೆದ ಭಾಗವಾಗಿ ಇದು ಹೀಗೆ ಮುಂದುವರೆದ್ರೆ, ಒಂದು ಉದಾಹರಣೆಗೆ ಪೋಲೆಂಡನ್ನು ಅವರು ಕೊಟ್ಟಿದ್ದಾರೆ. ಪೋಲೆಂಡ್ನಲ್ಲಿ ಅಪಾರ ಪ್ರಮಾಣದ ಜನರ ಮತ ಮತ್ತು ವಿಶ್ವಾಸ ಎರಡನ್ನೂ ಹೊಂದಿದ್ದಂಥ ಒಂದು ಪಕ್ಷವೇ ಅಧಿಕಾರಕ್ಕೆ ಬರ್ತದೆ. ಅದು ಬಂದ ನಂತರ ಆ ಸಂವಿಧಾನವನ್ನೇ ಬಳಸ್ಕೊಂಡು, ಅಲ್ಲಿನ ಜನರ ವಿಶ್ವಾಸವನ್ನೇ ಗಳಿಸ್ಕೊಂಡು ಅಧಿಕಾರಕ್ಕೆ ಬಂದ ಪಕ್ಷ ಸಂವಿಧಾನದ ಮೇಲೆ ಸಾಕಷ್ಟು ನಿಯಂತ್ರಣ ಮಾಡುವಂಥ ಮತ್ತು ಅದರ ಮೇಲೆ ದಾಳಿ ಮಾಡುವಂಥ ಕೆಲಸವನ್ನು ಮಾಡ್ತಾ ಇದೆ. ಸೊ ಈ ದಾಳಿ ಮತ್ತು ನಿಯಂತ್ರಣ ಹೇಗಾಗುತ್ತೆ ಅಂದರೆ ಒಂದು 10 ಅಂಶಗಳಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ. ಅದು ವಿರೋಧ ಪಕ್ಷಗಳನ್ನು ಹಳಿಯುವಂಥದ್ದು, ಅಂದರೆ ಅವರನ್ನು ಕೆಟ್ಟ ರೀತಿಯಲ್ಲಿ ಚಿತ್ರಿಸುವಂಥದ್ದಾಗಿರ್ಬೋದು, ಸಾಂವಿಧಾನಿಕ ಮೌಲ್ಯಗಳನ್ನು ಕಡಿತಗೊಳಿಸುವಂಥದ್ದು, ಅವುಗಳ ಮೇಲೆ ದಾಳಿ ಮಾಡುವಂಥದ್ದು ಇರ್ಬೋದು, ಮಾಧ್ಯಮವನ್ನು ನಿಯಂತ್ರಿಸುವಂಥದ್ದು, ಮಾಧ್ಯಮ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ನಿಯಂತ್ರಿಸುವಂಥದ್ದು, ಮತ್ತು ಸಾರ್ವಜನಿಕ ಮಾಧ್ಯಮವಾಗಿರುವಂಥ ಗೌರ್ಮೆಂಟ್ ಮೀಡಿಯಾವನ್ನು ತನ್ನ ತುತ್ತೂರಿಯಾಗಿ ಬಳಸ್ಕೊಳ್ಳುವಂಥದ್ದು ಇರ್ಬೋದು. ಅದಾದ ನಂತರ ಆಡಳಿತ ಸೇವೆಯನ್ನು ರಾಜಕೀಯಗೊಳಿಸುವಂಥದ್ದು, ನಾಗರಿಕ ಸೇವೆಗಳನ್ನು ರಾಜಕೀಯಗೊಳಿಸುವಂಥದ್ದು, ಮತ್ತು ನಾಗರಿಕ ಸಮಾಜವನ್ನು ಅದರ ವಿರುದ್ಧವೇ ಕೆಲಸ ಮಾಡುವಂತೆ ಒಂದಷ್ಟು ಜನರನ್ನು ಎತ್ತಿ ಕಟ್ಟುವಂಥದ್ದಾಗಿರ್ಬೋದು. ಜೊತೆಗೆ ಚುನಾವಣಾ ಅಧಿಕಾರವನ್ನು ಭ್ರಷ್ಟಗೊಳಿಸುವಂಥದ್ದು, ಮತ್ತು ಅಭಿವ್ಯಕ್ತಿ ಸ್ವಾತಂತ್ರ್ಯವನ್ನು ಹಣಿಯುವಂಥದ್ದು, ಮತ್ತು ಅತಿ ರಾಷ್ಟ್ರೀಯತೆಯನ್ನು ಮುಂದೆ ತಂದು ಜನರನ್ನು ನಿಜವಾದ ಸಮಸ್ಯೆಗಳಿಂದ ಮರೆಮಾಚುವಂಥದ್ದು. ಈ 10 ಹಂತಗಳಲ್ಲಿ 10 ವಿಷಯಗಳಲ್ಲಿ ಪ್ರಜಾಪ್ರಭುತ್ವ ವ್ಯವಸ್ಥೆ ಮತ್ತು ಚುನಾವಣಾ ವ್ಯವಸ್ಥೆ ಮತ್ತು ಸಂವಿಧಾನ, ಈ 3 ಮೇಲೂ ಕೂಡ ದಾಳಿ ಮಾಡುವಂಥ ಕೆಲಸವನ್ನು ಸರ್ಕಾರಗಳು ಮಾಡ್ತಾ ಬರುತ್ತೆ, ಪ್ರಭುತ್ವ ಮಾಡ್ತಾ ಬರುತ್ತೆ. ಇದು ಭಾರತದಲ್ಲಿ ಹಿಂದುತ್ವದ ಮೂಲಕ ನಡೀತಾ ಇದೆ. ಅದಕ್ಕೆ ನಾವು ಪರ್ಯಾಯಗಳನ್ನು ಹುಡುಕಬೇಕಾಗತ್ತೆ. ಅದು ಹಿಂದೂಸ್ತಾನಿ ಅಸ್ಮಿತೆಯನ್ನು ನಾವು ಮುಂದೆ ತರೋದ್ರ ಮೂಲಕ ಆಗಬೇಕಾಗುತ್ತೆ. ಸೊ ಈ ರೀತಿ ನಾವು ಅವರು ದಾಳಿ ಮಾಡ್ತಿರುವಂಥ ಸಂದರ್ಭದಲ್ಲಿ ಅವಕ್ಕೆ ಪರ್ಯಾಯಗಳನ್ನು ಹುಡುಕೊಂಡು ಅವುಗಳನ್ನು ನಾವು ಎದುರಿಸಬೇಕಾಗತ್ತೆ ಅನ್ನುವಂಥದ್ದನ್ನು ಪ್ರೊಫೆಸರ್ ಅರುಣ್ ಅವರು ಹೇಳಿದ್ದಾರೆ. ಧನ್ಯವಾದಗಳು.
Thank you for all those translations. Thanks. Thank you to all the panelists and also for the translation. Thank you very much. So I will moderate standing over here and possibly keep the discussion here. We'll be a bit elitist for a bit, and let's see if there's time to bring the public in as well. So it seems to me that this panel has reminded us about the need to safeguard the safeguards, right? In some ways that's the tension, or that's the puzzle or the challenge. And there's also the question of whether what began as a more state, nation-oriented understanding of institutions and what they could produce within a democratic framework is veering toward a nation-state-centered understanding of institutions and democracy. So keeping these in mind, I was just thinking, keeping these aspects of the discussion in mind, I was reminded of some kind of a metaphor from music actually, where you have ragas with singing, or like music with the Indian system of music at any rate, where you have dominant notes in a particular raga, and those dominant notes are almost like our institutions for the raga of democracy, which ensure that the rag stays within its range of notes and doesn't go into a bordering raga of, let's call it authoritarianism, or some kind of electoral autocracy, which Professor Sridharan wants to resist the usage of. But this movement, and of course, those kinds of system can also have ragas. I think Wagner has taught us at least that much. So what do we do to keep these important notes there? That's the question, it seems, so that we don't veer away from them. What kind of flight can we have together so that the birds that can keep the direction intact are where they should be? Those are images that also came to mind. And the major notes were things like independence that Aparna reminded us about, accountability that Ishwaran reminded us about, perception is something that Dr. Qureshi reminded us about, which is the people should know or be able to think that there is some kind of impartiality afoot in the way in which institutions are doing their safeguarding. And Professor Arun reminded us of crisis, reckoning with crisis, and then figuring ways by which we can become aware through the example of Sadowski's work about, where do we come back on track? Where do we come back to the railway track, if that were another third metaphor here? So how do we start this discussion? I want to start with the idea of the National Election Fund to maintain independence, to have some kind of accountability in public life, and the question of the opposition that Ishwaran also told us is important, that those who lose should not feel left out. What if the National Election Fund were to be funded by the winning parties, and those funds were to be given to the losing parties, and those funds were to be used for an independent media, so that there was less of, at least in electoral matters, a business model of journalism and maybe some other model. So I'm trying to think, what can we do in terms of institutional interventions through this note of money, which is a required note that should be dormant, it should never become the main one, because it will then take the tune in some other direction. So can we do something? Is there a way by which we can protect the opposition institutionally and protect those voices that belong in the opposition, but our neoliberal understandings of media don't let those voices come forward? So anything there that the panel may want to say? That's a broader question for everyone. But I also know that some of the panelists have questions for each other. So there are 2 mics to share. Aparna, would you start it off? Okay, and then if we could go in the order that people raise their hands with respect to interest. Aparna?
Sure. I just wanted to add another feature to the questions around independence, perception, so on and so forth, which is politics. I mean, ultimately, institutions can do only so much, and both the strength of these institutions as well as their ability to generally function, their independence, so on and so forth, will depend on politics, including party politics. I think Arun mentioned the saying in the US that it's separation of parties, not separation of powers. And if that were the case, again, globally, this lacuna in the Indian constitution of not thinking about political parties as important institutions safeguarding democracy. I mean, what could be more important as an institution safeguarding democracy? Therefore, having nothing about, either in the constitution or otherwise, about internal democracy of political parties or the internal structure of political parties, having nothing in the constitution about opposition rights, about entrenching opposition rights. In fact, the constitution moves away from that, at least from a constitutionalized leader of the opposition post, so on and so forth. The speaker's position being such a weak position, etc., would make me wonder, and this is just a question that I want to sort of also open up, to think about the space of political parties within our constitutional framework. What might be ways to strengthen that? And the other sort of element of this, which is the electoral element, which is to say that do we need to rethink the first past the post electoral system? I mean, is that if political power really is important, the way we do politics is really important, then is the first past the post electoral system really the most important one?
Thank you, Aparna. Dr. Qureshi, would you like to respond to some of these questions and then raise some others?
Only 9 minutes left and we have to have question from the audience. Two quick things. One, first past the post system, I was a votary and a supporter of the system. When I wrote my book, which you referred to, An Undocumented Wonder, The Making of the Great Indian Election, I described all the systems and supported first past the post. In my third edition after 2014 election, I changed my stance. Why? I'm not fickle-minded. Because what happened was, UP election, a political party got 20% votes, 20% vote share, 0 seat. Now this is the defect of first past the post. That is the first time when I thought we need to reconsider, and maybe proportional representation or maybe a mixed system is what we need to look at. That's a serious national debate that we require. But the main question was, although all panelists spoke very well, some interesting point made by the Professor Ishwaran was about the electoral process and electoral output. Here also there's something interesting which I have experienced, again referring again to my book, which is called, I repeat, An Undocumented Wonder, very pompous, high-sounding title. When I was about to finish the book, I came across Economist Intelligence Report of Global Democracy Index. And it described India as a flawed democracy. I was very angry, very upset. Look, this must be a Western conspiracy to show India down. Why are they showing us we are a wonderful election? Now, wonderful election does not mean wonderful democracy. The process is fantastic. And same democracy index gives us 9.7 out of 10 year after year. But our democracy quality index has been going down from 27 to 53 or now even lower. Why? Because when I studied it myself, because low women's participation, only 10% criminalization of politics, corruption, 30 crore people still illiterate. Now, if these are the things which are bringing us down, who can we blame? And we started blaming. Recently, when the report came, economists, our officers went, I read the report in Hindustan Times. They went knocking on the doors of economists. Look, why are you showing us poor? We are such a great democracy. Where do you collect the data? Look, they collect the data of 208 countries, same parameters. They don't have any special data for India. And they say, well, look, we will give you the data. On that basis, you rate us. So, which is, of course, very presumptuous and foolish of us to make such an attempt. We only made an ass of ourselves. Thank you.
Dr. Sridharan, would you like to make a few comments?
Just to add to what Dr. Qureshi said, I mean, first past the post to proportional representation. I've actually written a piece on this a few years back. It does not necessarily solve certain problems. And under proportional representation, small parties as well as minorities who can float their own party get a proportion of seats closer to the proportion of votes. So they get better represented by and large than they might get under first past the post system. But that does not necessarily support reduced polarization. If you take two countries, Israel and Sri Lanka, which have a highly proportional representation system, Sri Lanka since 1978 for its parliament, and Israel, the whole country is one constituency, like the Netherlands, which is a highly proportional system. But the polarization between Jews and Arabs in Israel and between Tamils and Senegalese in Sri Lanka is much worse than, say, between Hindus and Muslims in India under first past the post. It has not solved the problem of polarization. So that is something which is a bit independent of first past the post versus proportional representation. It's about the prevalent narrative, ideology and so forth, and the definition of nationhood in these countries. It's not just a question of, you can be better represented in parliament but have no executive power, no share in power at all. That's also a possible outcome. So I would say that one has to look at first past the post and proportional representation in a somewhat larger context. Thanks.
Arun, any comments or questions as well that you might want to raise?
No, I'll just say this, that I think for the last 2 decades or so, there's been a lot of thinking in comparative politics, comparative constitutional law, about design questions. And this is an illustration of that. Will first past the post or proportional representation get it? I think as we think of the moment that we are in, these tend to be very, and earlier I defended technocracy and technocratic knowledge, but I'm going to suggest that the solutions to the crisis we are in can't be done through questions only of constitutional design, right? I think if just going back to fourth branch institutions that we are talking about, in a recent publication, Professor Tryst says that if you look at fourth branch institutions where you create a web of institutions, the hope is that at any given point of time, some of them will work. Right? Some of them may be captured by the ruling regime, but hopefully some of them have some things, either independence or accountability mechanisms done in a certain way where you get it. But I think what we are seeing is across the world, those constitutional design assumptions are not working. Right? We live in a moment where the discourse of politics has changed. And I think, again, in the first panel, there was talk about how, and Aparna's point about all these things will not work if the politics is not, working in that way. Which is why I was suggesting that I think we have to we have to look at these. I'm not dismissing this. I think ultimately design questions will have an effect on where it goes. But I think we need to think a little beyond these technocratic issues to try and understand why is it that particular regimes are able to get that. Maybe in the wider populace, and I think Dr. Sridharan also talked about the disconnect between elite politics and mass politics. I think it gets to that. What is happening in the wider discourse? And maybe scholars need to pay more attention to that to understand what is happening before we then start thinking about what can you do in response. Yeah.
Thank you. So right now the panel seems to suggest that institutional design matters, but also the people who are going to run those institutions and are going to get elected or somehow selected to run those institutions must come from a mass that's been elevated into the status of a public that can play its role well, crucially. So not just, so Kratos matters, but so does the demos. Politics matters. Maybe these kinds of conferences at a more general, ordinary level, more discussions of the meanings of freedom and equality. I don't know if those have to be through citizens' assemblies or some other format, but in some ways, letting us know what it is that we want to safeguard through these institutions. Let there be some conversation at a more general level, but a robust and a really general one. There is a little bit of time to at least collect some questions from the public here. So I see 3 hands on this side and 1 there. So you will each get very few seconds to ask your crisp question. Is there a mic? So the gentleman right at the front there, and then I'm going to use my discretion a bit. And then yourself, the person sitting in front of Professor Jain. So, yeah. So, yes, to your right, yes. Very quickly, please.
Yeah, it's quick. My question is to Dr. Qureshi, specifically. Year after election, there is a problem persists in there. Every time media makes headlines, but again next election same problem repeats. Problem is that many people complain that their names are missing. So unfortunately in 2019 election, my own name was missing. Several decades I'm staying in Bengaluru and voting. And I'm not a kind of person, leave it. I approached the chief electoral officer. They took several meetings. Then they took permission from the chief election commissioner.
So the question.
Then they formed a committee.
The question.
Yeah. They formed a committee, and then I was part of that committee. We made several suggestions to this thing, but I don't know why important suggestions are not implemented. Again, the last election, several people complained that our names are missing. Is it deliberate act?
No.
Is there any solution?
I would request that you send those suggestions to me also. But I would like to say that names keep on missing from here and there. There can be various reasons. Clerical mistake, computer error or mischief, dishonesty, everything is possible, which is why Election Commission advertises again and again, please check your roll, please check your roll, and we don't. Because we have the voter ID card in our pocket, which gives us the confidence. Even if you have that in your pocket and you had voted 3 months ago, there is no guarantee that your name is still there. It may have got cut off for any reason. My request to all of you, please keep checking your roll and get it corrected as soon as you detect something is wrong. But it's a major ongoing problem.
Okay, so we will leave that for a discussion afterwards, sir. Your question, please, quickly, sharply.
Done. My question is to Dr. Qureshi sir as well. Firstly, Dr. Qureshi sir, I'm a huge fan of your work, especially your book on Islam, family planning and politics, the population myth. Getting to my question, so you spoke about the independence of election commission, right? Now, considering the current day scenario where the legislature is pulling ECI strings on one hand and the judiciary on another, also reflecting upon the Anuparanwa judgment, right? How do we ensure that independence, considering, you know, there is a play of the legislature on one hand, the judiciary on another, and the election really is being sabotaged? I mean, the independence is really being sabotaged.
Well, you're right. The Election Commission, for the first time in the last 6-7 years, has come under question. And when I hear criticism of the Election Commission, it hurts me, as if somebody is slapping me. Because, you know, the reputation take years to build and seconds to demolish. And I feel especially hurt, like all citizens, plus because I also added 2-3 bricks to that institution. The fact is that in the last 6-7 years, which is why, and I'm very hesitant to comment on my successors. They are brighter than me. But the fact that the whole world is questioning, there are editorials questioning them, something is wrong. We need to do something about it. And then the constitutional check and support. Supreme Court actually occasionally has come down heavily on the Election Commission. It never happened in our time. They were very respectful of us. But there, in one case, when for 25 days the model code cases were not decided on, Supreme Court lashed out at the Commission. Look, you can't sit over it. Decide one way or the other. Why are you sitting on it? It's not your property. You know, so therefore, the nation is concerned and we all have to put our heads together to see how to keep the reputation of these institutions, even the Supreme Court's reputation, mind you. We need to work on that to keep it intact. These are institutions we were proud of and we should continue to be.
So, thank you, Dr. Qureshi. There are possibly 2 more questions, but we will not wait for any responses. I request the persons right in front to ask those questions quickly. And we will close with that because there has to be a quick break for tea and the next discussion begins. Apologies to many who I could not identify as question
Thank you very
askers.
much. I am Dr. Anis Ansari. Mr. Sam Petroda has recommended that since EVMs are easy to be manipulated, the VVPATs should be printed with an ink which is lasting. Presently, it disappears. And in case of any question by the disputing candidate at the polling booth, recount could take place to compare the VVPAT with the poll result announced by the presiding officer. What is your opinion?
Yeah.
Okay.
No,
Dr. Qureshi, we'll just take the next question as well.
No, I am an old man, I forget. So, you know, I heard Sam Petroda, who is a great friend, a great technology expert, but I do not buy the attack on the EVM. And my final answer is, look at the Karnataka election 6 months ago. Prime Minister came here 34 times. They put everything into the election and still lost badly. If they could have manipulated EVM, do you think they would have spared it? So what better proof do we need? And there are other states also, West Bengal. My only suggestion would be, now the VVPAT, the Election Commission has clarified that the ink on the VVPAT can last 4 years. We don't even need it 4 years, only those cases which go to the High Court. But VVPATs are counted on the spot. And finally, the suggestion that the VVPAT slip should be given to the voter, I would not do that. Why? Because we have seen all kinds of cheating. What will happen if you give it to me? I'll take it in my pocket, put some bogus thing in the booth and show it to my master who had given me 5,000 rupees. and that is how the cycle will begin. It is better what I have suggested on the VVPAT itself, introduce 2 buttons, red and green. If I'm satisfied on the screen, okay, this is the guy I chose, I press the green button. That is voter verifiability, 100% foolproof. And from there, the chit get compared. And my ultimate recommendation is, even if you have to count 100% slip, even if it takes 1 extra day, so what? The country waits for 2.5 months for the result. So 1 more day will not make a difference. So Election Commission saying it will take 5-6 days. You have been a Chief Secretary, you have been a returning officer. A full ballot paper, newspaper size, we used to count in 12 hours or 14 hours. To say this a small slip of a visiting card size will take 5-6 days to count, what are they saying?
Thank you, Dr. Qureshi, but also thank you, Professor Arun, Professor Ishwaran, Professor Aparna, and all of you for raising the questions, but also for being present. So thank you very much, everyone, for giving off your time. A tea break now, followed by the next panel. Thank you.